Hi, Jonathan. All right. Well, welcome everyone to the 2025 annual general meeting of the International Law Association. And we thought it would be really nice to have a brief conversation between Matthew Kronby and Jennifer Hillman about what's been going on trade because we've been following it, some of us much more closely than others over the last year, and it's certainly been an exciting time. So just before we start, I'd say that in keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, we acknowledge the traditional territories and ancestral lands of the First Nations, Inuit, and Métis people. And as we meet virtually today, let me acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters where we meet online today. And with that, welcome you. I'm Oonagh Fitzgerald, for those who don't know me. I'm president of ILA Canada, and we're going to start with a rapid fire international trade law update. We've had a full year of the second Trump administration, and it spelled trade chaos and for Canada and much of the world. Prime Minister Carney recently spoke about a rupture and the end of the rules-based system. These two experts, Matthew Kronby and Jennifer Hillman, will help us reflect on what has happened to the World Trade Organization and the global trading system, and consider what future trade landscape may be. So first of all, Matthew Kronby is a partner in the international trade practice of Osler LLP. He provides advice and advocacy for companies and governments in cross-border trade compliance matters, including trade remedies, tariffs, and treaty disputes. He spent the first part of his career in the government, serving as head of Canada's Trade Bureau and leading legal teams in WTO and NAFTA proceedings and FTA and investment treaty negotiations. Matthew teaches international trade and investment arbitration at the University of Toronto, Faculty of Law, and is appointed to Canada's roster of panelists. Jennifer Hillman is a professor of practice at the Georgetown University Law Center and a fellow of Georgetown's Institute of International Economic Law. She's also co-director of the Center for Inclusive Trade and Development. She served as a panelist for the second dispute under the USMCA, or CUSMA, as we call it. She completed a term as a member of the World Trade Organization's appellate body, and prior to that, she served for 9 years as a commissioner at the United States International Trade Commission, and before that was general counsel at the Office of the United States Trade Representative. Alors, je vais parler en français et la présentation des deux conférenciers sera en anglais, mais vous êtes bienvenus de poser vos questions en français. Ça serait excellent. On est capable de traduire pour tout le monde. Okay, so the first question we're going to have is for Jennifer and Matthew is what happened to the rules-based trading order? Not just in the last 12 months, but over the last decade or longer, and why? And how do the US and Canada figure in both upholding WTO rules and undermining them? Over to you, Matthew, first.
Okay, well, first of all, thanks for including me on this panel. You left out the most important thing, which is that I'm a member of the ILA Canada board as
Sorry.
well. I also want to acknowledge, if we're doing acknowledgements, that there are some other real experts in this area on at this meeting, and so it would also be really interesting to hear from them too in the questions and comments. It seems to me and that there's different ways of looking at what happened, because you talk about Prime Minister Carney's reference to a rupture. There is, in my view, undoubtedly a rupture in the Canada-US relationship. There's a rupture in the multilateral, meaning WTO system. I think most people would agree that the WTO is not the organization it once was. And to your point, that process began well before the second Trump administration, but certainly exacerbated by Trump 47. But I wouldn't say there's a rupture for the rest of the world, because it seems to me that most of the world's trade is still conducted under a rules-based system, including WTO rules, but also including a growing number of regional, bilateral FTAs, the most recently announced one, a major one, being the EU-India deal. And trade volumes are up, and the general trade trend is that the rest of the world is continuing to liberalize its trade and continuing to enter into new rules-based trade agreements. So maybe I'll stop there. I can come back to this, but give Jennifer a chance.
Well,
Jennifer?
yeah, well, thank you, and it's really a pleasure to be here and a pleasure to see some familiar faces on the screen. So I'm going to take a little, maybe I'm on the one hand, I agree with Matthew that I don't think there is as a complete a rupture as might be described, but I do think it's important to think about how far and fast the United States has moved, if you will, away from the rules-based order and from the WTO, and to reflect on the fact that I don't think it's just Donald Trump, unfortunately. So I don't think it's just waiting and hoping for him to go away as soon as possible in order for everyone to get back to it. Because for me, a lot of the concerns go much deeper. I'm going to start with, and again, I think it is more true in the United States, but it's true in a lot of other places where there's really been waning faith in the trading system to deliver on economic growth, and I would say particularly on widely shared economic growth. And again, that's much more true in the United States than other places where, in the US, we have seen this incredible, chasm between the haves and the have-nots, where the top 1% are doing exceedingly well, and a lot of that doing exceedingly well comes out of the trading system and taking advantages of the trading system and are leaving everybody else behind. And that's caused a lot of pushback on the system. And again, I think it's been to some degree unleashed by a lot of what you hear from Donald Trump, but it's not Donald Trump alone. This perception of, basically for whatever you think is wrong in your life, that your schools are not as good as they used to be, the roads are crumbling in front of you, your wages haven't kept up, prices are going up, whatever it may be, blame foreign. Blame foreign goods, so we're going to put on all these tariffs and build all these walls. Blame foreign people, so we're going to stop immigration. Blame foreign money, so we're going to put all these controls on investment. And that then breeds this sense of, we don't trust our trading partners. We don't trust each other. So I do think there's these deeper sort of underlying currents in it. And then to me, the other one that really needs to be talked about is the implications of the rise of China. Again, as somebody that teaches international trade law, we always start out with that, Ricardian principles of comparative advantage that you always teach. And I'm always struck by, okay, this worked when in the Ricardian example, when it was, England and Portugal, two countries that had at least at some level, sort of comparable systems. I'm just not sure that the system, can really work when you bring in a country like China that has been able to rise so fast and largely, in a significant way on the back of, everything from suppressed wages to significant amounts of subsidies to again, initially starting out with a lot of taking of technology and intellectual property from others, etc. That rapid rise of China, I think, and the perception, at least the perception, that the WTO is not capable of addressing those concerns, I think has fed into this notion of the rules-based system is not going to be able to deliver prosperity for me. For the average person. So I think that is very much underlying it. I don't, and I think there is going to be a need to address some of these deeper concerns if we're going to get back to a sort of restoring faith in the overall system.
Thanks, Jennifer. And a while back, we were all hearing about the World Trade Organization and its dispute settlement system as really the crown jewels of international adjudication and international dispute settlement. But just for the reasons that you've already mentioned, it does seem that, well, we know that the appellate body they haven't been able to staff it up with new members. So there's been a pullback away from the appellate body. Why do you think that is? You think, like, where do we go from here? Was it too rule? Were the lawyers? Was it a case of hubris of the lawyers thinking it was good, it was better than what the rest of the world wanted, that we really didn't want a system that was so rules bound, that we need a more flexible system? So maybe I'll put that question to Matt. Just any observations about the rise and kind of slight questioning now about the double.
Well, I mean, I think certainly the demise of the appellate body, which began probably under the Obama administration, was more a function of what Jennifer's alluding to, which is the rise of China and a perception that WTO rules were incapable of addressing China and China's economic conduct. So I think that's really the start there. I don't think that the concern is so much about a broad range of other issues that were litigated under WTO dispute settlement. I mean, countries win, countries lose, but for the most part, they accept the results of those decisions. I think largely what we've seen with the demise of the appellate body was a frustration that to Jennifer's point, that the system was incapable of addressing China's conduct in a number of the areas that she referred to. But maybe just before we get to that, can I just step back, because this is the International Law Association. I just want to make clear what we're talking about when we're talking about the decline of a rules-based system, and particularly a multilateral system. And it seems to me that the dispute settlement mechanism is just one part of it. There are two, I think, more fundamental elements of the system that are really critical here, at least that have been damaged at the multilateral level, and particularly damaged by Trump 47, and that is bound tariff rates and the MFN principle. Those to my mind are the key elements. So the tariff binding is the commitment of countries. You know, this goes back to the GATT, to lock their customs tariff rates in such that they can go lower than the rates they've committed to, but they can't go higher. Trump's tariffs, including the ones that have been struck down, in particular the IEEPA tariffs, are a blatant breach of that principle. Other countries have followed along. Some of Canada's actions, partly in response to the Trump tariffs, but not only, going back to the Biden administration too, have also been in breach of that principle. The other principle being MFN, that you will, most favored nations, that you have the same tariff rates that apply to all WTO countries, or that a given country applies the same rate to all other WTO countries, with certain exceptions, the most notable of which is the exception for free trade agreements, under which countries can have preferential rates. But again, the Trump Liberation Day tariffs do away with that, or an abrogation of that principle as well. And so those are foundational for a multilateral system, but and without them, you don't really have a secure and predictable global trading system. So
can I just add a little, because I do think with respect to the appellate body and the sort of rules-based system and having an adjudicator, here's where I do think the U.S., on the one hand, bears more of the blame and is sort of more responsible in a way that is maybe just a little bit unique and different in the United States. And what it leaves me with is I'm not sure then where that leaves us in terms of how do we fix the system. I mean, to me, it's just always it's always interesting. I always sort of tell students to think about the fact that the United States has never agreed to join any other international court. We don't accept universal jurisdiction of the, International Court of Justice. We're not, a party to the Inter-American Court of Human Rights. We, again, we disdain, the International Criminal Court, on and on. The United States simply stays out of all international courts, largely on sovereignty grounds, that we're not going to give up our sovereignty. And yet we joined the WTO with its binding dispute settlement system, with its appellate body. Why? If you go back and look at it, a lot of it was because there were trade-offs. I mean, there were certainly many members of Congress, even when the Uruguay round went through, and the WTO and its dispute settlement system was established, who said, I don't like this. I do not like this binding dispute settlement system. Why are we subjecting ourselves to this? But I really like the agreement on agriculture, or I really like the, TRIPS agreement on intellectual property. I really like this services agreement. So there was perception of a bargain that you're going to accept this binding dispute settlement system that you don't really like, at least for some, in exchange for these other things. And over the course of a lot of years, my sense is that a lot of the members basically decided that they didn't really like the terms of that bargain. And therefore, they wanted to have some reconsideration. And what they did not want to give up is any of the things that they liked. They simply wanted to get rid of the appellate body system. I also think, again, it was just a series of decisions, in this narrow area of trade remedies that ended up, poisoning the well, if you will, because what happened is every single time the appellate body handed down a decision that was against the United States in this trade remedy area, many, many, many of the industries that were involved would go up to Capitol Hill and tell every member of Congress how horrible and terrible it was that the appellate body had taken away this right that the United States had to impose these trade remedies. And it got to the point where, again, the last time I, went in front of the Congress to talk about any of this, literally the only thing members knew about the WTO was they hated the appellate body. They couldn't tell you anything else about it, but they hated this dispute settlement system. So part of me thinks that degree of ire at the WTO and the appellate body system is unique to the United States. And on the other hand, some of the broader systemic concerns that Matthew is talking about are very real for everyone, that we're approaching this notion of undermining the core bedrock provision of the WTO, which is most favored nation. You cannot discriminate on the basis of nationality. And yet, I think it's not here, just the United States. There are now many countries, I think that you're going to have to rethink this MFN system, because not every country, and again, I think a lot of people here are prepared to put China into that category, deserve to have MFN because they're not playing by the same rules that everybody else is playing by. And this notion that MFN belongs to, the heart of it is that you're going to treat everybody the same. Underlying that basic principle is everyone deserves to be treated the same. Everyone has earned this same degree of fair treatment. And it's that basic understanding, that basic acceptance that everyone deserves to be treated the same, that I'm not sure is there anymore. And so I do think it is rethinking, or at least reconsidering how we approach MFN, that is going to be one of the discussions moving forward.
And if I could just contextualize, maybe, because I know not everyone who's in the audience is a trade lawyer. And this sort of ties back to, I think, what Jennifer was saying earlier. These trade remedies decisions that aroused the ire of U.S. members of Congress and administration. When we're talking about trade remedies, we're talking about anti-dumping and countervailing duties. And this was almost entirely in the context of Chinese conduct. The notion that China, through massive state involvement, was unfairly subsidizing its exports, and that China, through massive state-supported overproduction and excess capacity was as a result dumping its goods in foreign markets, and that the WTO system wasn't doing enough to stop it.
Thanks for that, Matthew and Jennifer. So let's move to our last question. And those in the audience who'd like to prepare a question, get them ready. So where does this leave us? We know that public international law depends on trust and good faith. And we know the WTO has been an institution that encouraged ongoing diplomatic engagement and consensus building. So how can medium-sized economies adapt the strengths of the multilateral trading system and learn from its weaknesses to construct some kind of a new plurilateral, bilateral trading network that bolsters their economies and insulates them from great power pressures? And what will be the role of trade lawyers in that reconfigured trade world? Matt, would you like to start with that?
I'd love to defer to Jennifer, but I could certainly start from one perspective. I mean, I think there maybe, and this goes to something I was sort of getting at when I started. In a sense, that many aspects of the WTO, many of the obligations in the WTO, the rules of the WTO, we're talking about international law here, still survive, are still applied regularly in trade between most countries. Most of I think it's 166 current members of the WTO. These include things like, amongst these other countries, mostly, bound duty rates, national treatment, prohibitions on quantitative restrictions, regulatory disciplines, even among some of them binding dispute settlement. And these principles have been incorporated into regional and bilateral trade agreements. And what we see in the WTO has, to a large extent, been a model for regional and bilateral agreements for the last 30 plus years. Now, the problem with having all of those agreements at the same time, that does preserve a kind of international rule of law, but you get the problem that Professor Jagdish Bhagwati talked about in a very famous I think it was 95 article, where he talked about the spaghetti bowl effect, the friction that having a whole lot of different systems and different rules poses for businesses that are trying to trade internationally and establish global supply chains. And so this is always going to be the tension if you don't have a true multilateral system. It seems to me, all the more so if you do away with broader principles of MFN, as Jennifer was alluding to. You're certainly going to need trade lawyers to help navigate that, but also to build those various agreements, those strands of spaghetti, and then to figure out a way through them. So maybe let me turn it over. I'm conscious of the time. Let me turn it over to Jennifer.
Well, thank you. I'm going to start with where your question began, which is, trust and good faith. Because I would say, it's very clear to me that for whatever else you can say, what the last year has brought to the whole world by Trump's actions has been chaos. And the chaos is, if you will, the antithesis of the notion of trust and good faith. And it to me, the hope that I bring that I bring out of all of this complete mess, again, very much fostered by Trump in the United States, is a recognition by so many of the trade lawyers, of the businesses, and of so many others of, in the words as Joni Mitchell sang it, you don't know what you got till it's gone. I mean, this sense of, what did we really get out of the WTO? Yes, we did not get all of our problems with China solved. We did not get a whole lot of things. But what you got from a system that was a rules-based system that had at its core these ideas that Matthew was talking about of bound tariffs, that you knew what you were getting when you put those goods on the water, you knew how much the tariff was going to be. You knew what you were going to not be discriminated against just because you were from X country or Y nationality, or because it was an import as opposed to a domestic product. That amount of certainty, predictability, stability is, I think, what you see now everyone in the world craving. Really needing to get back to a notion of, I can count on my trading partners when I need them. When a pandemic breaks out and I still need food, or I still need parts, I still need components, I can count on my trading partners. That's what the system really wants, is a system that helps, again, spread economic growth more evenly, but has this at its core, this notion of I can count on it. I can trust it. I have faith in it. And whether that faith comes from, again, exactly rules that are then adjudicated and are bound and are subject to, again, a binding dispute settlement system, or whether they are other ways of reaching a consensus, there's no question that what the system is going to have going forward is this notion of, how do I know exactly how my trade is going to be treated from beginning to end throughout a supply chain, throughout a transaction, throughout years of time? And I think what we're seeing now is that is not necessarily going to be able to be possible, maybe under a multilateral rules at WTO 166 countries, unless and until the WTO can figure out how to make decisions that don't require an absolute consensus of all 166 countries. What you are going to see is more and more regional, plurilateral agreements. Both within regions, but also, I think, within sectors. I mean, you're seeing it right now grow up in the critical minerals area, where there is a recognition on the part of the United States, Canada, and many others that are like-minded, that access to critical minerals and the ability to process and trade in critical minerals is going to be essential for all of us, since critical minerals are absolutely needed for everything from EVs to batteries to defense systems. You're going to see potentially agreements in sectors, in regions, in other ways that are trying to, again, build that trust and good faith, but on a somewhat smaller scale than the broader overall WTO rules. But I think that's the road that we're on. Part of me draws some comfort from watching the horror show of the tariffs that the Trump administration has wrought, because I think a lot of us feared at the beginning of this that we were on the Smoot-Hawley road, that we were going to see everybody start doing tit-for-tat tariffs, and that we were going to be right back into the situation that we were in the early 1930s, and it didn't happen. And it didn't happen largely because governments like the Canadian government and governments like many of the other small and middle income powers that you're talking about didn't choose to go down that road. They remembered the lessons of the 1930s and did not choose to entirely just retaliate, and have beggar thy neighbor policies. So to me, there's a core there of a recognition. And again, I think that is what Mark Carney was talking about in his Davos speech, this recognition that we're not going to end up back at the system that we had, that we might all nostalgically want, but it isn't coming back. But instead, we've got to figure out how to build these overall coalitions with that notion of trust and good faith at their core.
Thanks so much for that, Jennifer and Matt. Okay, with that, I think we should turn it to the rest of the participants in this call to see if anyone would like to make a further comment or pose a question. I know there are many trade experts on this call who probably have opinions about much of this. Pressing questions, insights they'd like to share? You can raise your hand if you like.
Yeah.
Okay, I see Ramesh. Go ahead.
This is a very wonderful opportunity to learn from distinguished professors and experts. A couple of questions. especially trade deficit, persistent trade deficit. If one country is always in profit versus another country always in deficit, means that country is bound to be poor. So in that context, is tariff good or bad? Can you give me some idea? Thank you.
A quick response if you can. Matt, do you want to go, or Jennifer?
I'm not sure I fully understood the question, but I think I challenged the premise that a trade deficit is a sign of a country's poverty. I think in many cases a trade deficit is a sign of a country's wealth. And I think certainly while there may be certain circumstances where tariffs might be warranted, I think most economic theory would still, as it has for many years, postulate that overall tariffs reduce economic welfare rather than increase it. I mean, obviously, there are a lot of subtleties to that point, but the question was asked at a high level, so I'm answering it, or I'm trying to answer it at a very high level.
Thanks for that, Matt.
If you want further embellishment on that, for what it's worth, in the course of this litigation before the United States Supreme Court over whether or not Trump had the authority under this International Economic Emergency Powers Act, a very large group of very prominent trade economists submitted an excellent brief. Again, if I get a second, I can stick a link to it in the chat about this very issue, because one of the underlying premises of this lawsuit is that those IEEPA tariffs were based on the notion that there was a national emergency in the United States because we had these trade deficits. And, there was a lot of tension because the statute says that you can impose these measures for emergencies that are unusual and extraordinary. And so part of the brief was focused on the fact that the United States has run a trade deficit every single quarter for the last 50 years, 50 years. And so part of what the economists were arguing is, how can this be unusual or extraordinary if it's happened for 50 consecutive years? But the other part of it was, why is this an emergency? It's not a problem. It is, as Matthew said, a sign of strength in the U.S. economy in terms of how much it is a sign of both drawing in foreign investment into the United States and a sign of growth. So I think there is a lot of debate over this issue of what role trade deficits play. And to me, one of the key issues that's been focused on more recently is part of the answer to that also depends on whether what is causing the trade deficits, and whether there is a perception that your trading partners are engaging in fair trade or not.
Thanks very much for that very comprehensive response from both of you. I think we have time for one more short question or comment. If anyone else would like to make a comment or question.
Yeah, I could ask one. It's like a new topic. What about there's a debate on origin of goods. And now there's some sort of, at least within CUSMA or elsewhere, this notion that nationality of a company or characteristics of supply chain could have an impact on the origin of good, not only territorial. Do you have any thoughts on the future of this new notion of the origin of goods linked to the nationality and of a company?
I mean, I understand the genesis of it. I mean, part of it is, for a long time, many traders really didn't care all that much about the origin of the goods, because when we lived in a world of most favored nation where you did not discriminate against any country, it didn't really matter whether your good was made in Cambodia or Vietnam or Malaysia or Thailand, because the tariff was the same from all of those countries. And so you would simply declare the origin to be the most recent place in which any amount of work was done, without really carefully thinking through whether that origin was correct. So again, with Trump declaring different tariffs on every country, it has forced this focus on, understanding exactly where the goods are made. And as soon as you do that, it starts to focus an attention on the fact that those things that are coming out of, in theory, Cambodia or Vietnam are made in 100% owned Chinese facilities that happen to be located in Cambodia or that happen to be located in Vietnam, and on the ability of China, for example, to just pick up and move a factory in very short order to another facility, across a given borderline. So, and yet the goods are in every other way, considered made by, if you will, China. So this, I do think this is a growing movement. And there are those that think that the technology to do this in terms of casting origin to be by wherever the beneficial owner of the production facilities comes from, that again, it's much more readily available to trace in that way than it was in the past. And there are some that think we ought to be going down that road. I mean, I don't know that it's, in the near term, but there are many that think that that would be a better approach than leaving it tied simply to, a individual country of origin.
I would say, and in the Kuzma context, to Jennifer's point, the issue is again China and Chinese facilities in Mexico principally, but it does. I mean, the implications of basing rule of origin on ownership of the facility, not just where goods are produced, is potentially quite profound for foreign direct investment. And I certainly haven't thought that through carefully. I mean, I'm a trade lawyer. I'm not an economist, but I'd have to think that the implications are potentially very significant, and it would be quite a radical change.
Thank you very much, Matt and Jennifer and Bernard and Ramesh, for your questions and for the great answers you gave. It does sound like there's a lot of challenging issues, and you managed to succeed in the challenge of discussing it in half an hour, and I really appreciate that. Just giving us a little bit of substance before we move into the more administrative aspects of the AGM. So thank you so much, Jennifer. Thanks so much for joining us from England, and have a good evening. And yeah, people should definitely check out all the documents related to the case in the Supreme Court if they want more information about this. Thanks, Matthew. Okay, so
Thanks, Jennifer.
wonderful. So why don't we continue